Hi again. Thank you all for joining. My name is Kalli Joslin, and I'm the First Amendment Issue Director for Georgetown Law's chapter of the ACLU. I'm very excited to bring you tonight's panel on religion and the Constitution. Before I begin, I would like to let everyone in attendance know that this event is being recorded and it will be shared on our organization's YouTube page. This event is also live captioned, which we're very excited about. At the end of the panel, attendees will have the opportunity to submit questions through Zoom's Q&A feature. I will then be able to ask the questions to our panelists, who I would now like to go ahead and introduce. First, we have Dan Mach, who is the director of the ACLU Program on Freedom of Religion and Belief. He leads a wide range of religious liberty litigation, advocacy, and public education efforts nationwide, and often writes, teaches, and speaks publicly on religious freedom issues. Dan currently serves as an adjunct professor of law at the George Washington University School of Law, focusing on constitutional law and religious liberty. Prior to his work at ACLU, Dan was a partner in the Washington, D.C. office of Jenner and Block, where he specialized in First Amendment law. Second, we have Richard Katskee, who is Vice President and Legal Director at Americans United for Separation of Church and State, where he litigates religious freedom issues arising principally under the First Amendment. Richard previously served as the Deputy Director of the Program Legal Group in the U.S. Department of Education's Office for Civil Rights, where he led development of federal policy implementing anti-discrimination laws for the nation's schools, colleges, and universities, and a member of the Supreme Court in appellate practice at Mayer Brown LLP. He has taught church state law at the American University Washington College of Law and ethics at the John F. Kennedy School of Government and Harvard College. Okay, let's get started. I have a question for Richard. The Supreme Court has been very active in the religion realm over the last 5 years or so. Recently, they've decided a handful of cases dealing with bans on gathering for religious services in response to the COVID-19 pandemic. The most recent of those decisions came out just this past Friday, including what I believe is Justice Barrett's first opinion. How is this decision different from the decisions that came out on the same topic in 2020?
Well, let me give you a little background, but first of all, thank you, Kalli, for having me, and to all of you. It's really a pleasure to be here. Look, as we all know, state and local governments have put in place a bunch of restrictions over the past year to limit the spread of COVID-19. We're all living with that, right? Here we are. They've ordered that businesses be closed, limited the numbers of people allowed, barred the size of particularly indoor mass gatherings, and what's happened as a result is most houses of worship switched to online services, doing them like you're doing school and we're doing this program now. That turns out to have been a really good thing because epidemiologists have determined that big groups sitting together for long periods indoors are really dangerous, and that it's even worse when people are singing or chanting together because that basically sprays the virus all over. In fact, all across the country, there were huge clusters of infections and lots of deaths traceable to houses of worship, even when they were trying to implement social distancing. And this is all, I wanted to give you a little bit of a feel for the background, and then I'll talk about the decisions that we've seen. Because look, dozens of lawsuits across the country were filed despite the fact that most houses of worship are complying with the requirements. These are suits where the houses of worship are arguing that they have free exercise rights not to follow the restrictions. In fact, a few of the cases have churches and gun shops together as plaintiffs, with the gun shops also asserting Second Amendment rights. Now, in the overwhelming number of these cases in the lower courts, the courts have held that that these general restrictions on particularly indoor gatherings is what they were, are constitutional as long as they don't subject houses of worship to stricter standards than, call it, analogous non-religious gatherings. Things like concerts and lectures and stuff like that, movies. Applying Supreme Court precedent going back more than a century, the courts basically said, of course government can act to limit the spread of a deadly disease, and that's true even if it means limiting religious gatherings like everything else. Just a handful of cases came out the other way. They were pretty much all of it from the Sixth Circuit, where the courts for some reason thought that it would violate the Free Exercise Clause to subject religious gatherings to stricter caps than what apply to grocery shopping. In May and July, to get to Kalli's specific question, in May and July, challengers to California's and Nevada's restrictions sought emergency relief from the Supreme Court. They went to the Supreme Court and said, can you block these things, mostly while we're litigating? Now, by a 5-4 vote, with Justice Ginsburg still on the court, of course, and the Chief Justice joining the 4 more liberal justices, the court denied their claims. And what the Chief Justice said at the time is basically this: there's nothing unfair to religion about applying to the same standards to worship services as to things like concerts and movies. And that sitting in the pews for 1 or 2 or 3 hours for a service and chanting together and all of that, that's just not like walking through the grocery store. And finally, that courts should generally defer to public health experts. Now, though, after Justice Barrett's confirmation to the court replacing Justice Ginsburg, religious plaintiffs brought those sorts of cases back to the court. In fact, some of the very same cases, as well as some others. Starting in November, the court did an about face in a decision called Roman Catholic Diocese of Brooklyn against Cuomo, which was on what's often called the court's shadow docket, a decision without argument. The court decided the case the opposite way, leaving Justice Roberts and the 3 remaining liberals in the minority. Here's what's different about that decision. The new majority held that New York had improperly singled out religion for disfavor by applying what they had were, depending on how severe the COVID transmission was in your area, either a limit of 10 people or a limit of 25 people. And what the court said is that that was disfavoring religion because the state allowed essential businesses, things like grocery stores again, to have more people than that inside at the time. Never mind that trying to compare things that epidemiologists say are like versus different in terms of what the health risks are. The logic was basically that because religious gatherings didn't get the best treatment of anybody, that was unconstitutional disfavor for religion. Now we have plaintiffs in 3 cases challenging California's closure orders that have similarly sought emergency relief in the Supreme Court, because the lower courts were still, in a lot of respects, allowing the states to enforce their bans or their limits on gatherings. And so Friday night, after hours, in a case called South Bay United Pentecostal Church against Newsom, the court held that California couldn't bar all in-person indoor religious services, even in the most severely affected areas of the state. Now, the court didn't prevent the state from implementing 25% capacity restrictions in those regions and 50% capacity restrictions in places where the virus was bad, but not as bad, the transmission rates were. The court also declined, at least so far, to block a ban that the state had put in on indoor singing and chanting in groups. But the court emphasized that the plaintiffs could continue to fight their cases and could come back with more evidence if they wanted to, which in itself is a little mysterious because the parties had already presented extremely detailed factual records. But as will be maybe a theme tonight, the justices sometimes play a little fast and loose with the facts. Now, just the last couple of things I want to say are Justice Gorsuch filed a statement joined by Justices Thomas and Alito, essentially a concurrence, saying that the ban on indoor singing should also be enjoined, and also saying some things that make it sound like those 3 justices may not think that these percentage capacity restrictions, like saying you have to limit your worship service to 25% capacity of the sanctuary, like even those may not be okay either. As Kalli said, Justice Barrett issued her first signed opinion, which was a separate opinion also joined by Justice Kavanaugh, saying that the plaintiffs didn't carry their burden in challenging the singing ban, so they wouldn't have enjoined the application of that ban, but the plaintiffs might. It also appears, though, I think importantly, that those 2 justices weren't prepared to vote to enjoin California's percentage bans, these 25 and 50% capacities. Okay, so what? The new majority is going to block at least any moderately strict bans or limitations on the number of people attending religious services, apparently regardless of the severity of the outbreaks or the health concerns in the area. But the majority hasn't made clear yet what other types of restrictions might not be allowed, mask orders, limitations on singing, all of those other things. And meanwhile, so those questions are being litigated, as are questions like, what about religious schools that are challenging the restrictions in the same way that the churches have been? So all of that is being litigated actively right now. Let me stop there and let either Dan jump in or Kalli direct us a little bit.
Yeah, I don't have much to add to that. I think that was, as usual, Richard, an effective, thorough summary. I do think it's interesting, one of the themes, Richard alluded to some of the themes, one of them is the direction in which this court is going on religious liberty. And I think it is a pretty clear direction that is receptive to free exercise claims and hostile to Establishment Clause claims. That's going to be one of the themes. What's interesting about the latest California order is that they didn't have 5 votes for the most extreme position. The most extreme position, as Richard explained, was expressed by the 3 justices who said all of these challenge restrictions are impermissible. And several of the justices, even in the majority, weren't willing to go that far. So I think where we're left today, I mean, these are all open questions, and as Richard said, this is a shadow docket. So we'll see if anything develops on the real docket with oral argument and things like that. But there at least is an apparent willingness to allow some restrictions, not as many as states have imposed, but the percentage capacity restriction, the 25% capacity, which a majority of the court allowed to go through, I think is guidance for states moving forward as they try to deal with this pandemic. And so it wasn't the case that their hands are completely tied. I think the 3 most conservative justices wanted to tie the hands of states entirely, and that didn't happen.
And one more thing that, as Dan was speaking, it triggered another thought to share, is that when we're thinking about what these cases tell us about the broader, the court's broader approach to religion issues, Justice Kavanaugh has written now a couple of times with a particular theory, what he and some others call most favored nation status, which says this: when you're looking at laws or regulations that happen to impose restrictions on religion in one way or another, look to see whether the religion is getting the very best treatment of anybody and anything. If it isn't, then strict scrutiny and the restriction is likely to fail. And that seems to be without regard to, and again, getting back to what public health officials and epidemiologists say, that seems to be without regard to the actual risks and threats that are associated with different kinds of gatherings. It's just figure out who gets the best thing, and religion has to get that as well, or else it's discrimination against religion and it's unconstitutional. That seems to be his theory.
It's going to be really interesting to see which state restrictions make the cut and which don't as this litigation advances. But because there's so many topics to cover, I do want to go ahead and move forward. Dan, last summer, the court decided Espinoza v. Montana, which centered on school voucher programs at religious schools. What did the court say in Espinoza, and how broad is that holding?
So a little background. There used to be a great deal of cases about whether states could fund religious schools consistent with the Establishment Clause, with many cases suggesting that direct funding of religious activity is absolutely barred by the Establishment Clause, irrespective of who else is getting funded by the state. Now things have flipped so much. The question isn't whether states are allowed to do that. It's whether states must provide taxpayer support for religious schools. So the Espinoza case was yet another example of this, with the court essentially ordering the government, in this case, the state of Montana, to fund religious education. The Espinoza case was about a school voucher type scholarship program in Montana, which would have diverted millions in taxpayer dollars to private schools. And the vast majority of those private schools are religiously affiliated. One central problem with this program was that it violated the Montana state constitution, which, as in most states around the country, has a provision that includes heightened protections against government-funded religion. So in other words, where the federal constitution, as the Supreme Court interprets it, has fallen down on the job, these state constitutions can pick up the slack. So to avoid a violation of this state constitutional provision, which forbids taxpayer funding of religious education, the Montana Supreme Court struck down the whole program, both for religious and non-religious private schools. That way, no one would get the money. Notwithstanding that, the US Supreme Court held in a 5-4 decision that the cancellation of the scholarship program by the Montana courts violated the federal constitution, the federal free exercise clause. Basically, the US Supreme Court concluded that the Montana court was engaged in an act of discrimination against religious schools by eliminating the whole program. So, basically the holding was, once the government has a funding program like this, it can't exclude religious groups just because they're religious. Now, again, this was the holding, even though at the time the US Supreme Court got the case, there was no discrimination whatsoever because the entire program had been enjoined. So that's basically where we stand. There are still some avenues left open for states to bar funding of religious activity. The Supreme Court has made a distinction between status and use. So in the Montana case, the court said that you cannot, as a state, deny someone funding, in this case the religious schools, simply by virtue of their status as a religious entity. But they left open the avenue of barring funding to something because of the religious uses to which the taxpayer funds would be put. So this status use distinction is still alive. There were some justices who wanted to kill that entirely, but that did not happen. So that's still an avenue open for states who want to protect their own state interest in not funding religious institutions. And that's consistent with some of the basic principles underlying the First Amendment, going back all the way to the founding of the US government.
So Dan, as always, put his finger on precisely what I think is most important and interesting about the decision is that aside from sort of a backflip in how we traditionally understood the law, is the fact that after the state Supreme Court had seemingly resolved the matter, saying nobody gets money, no problem, the court reached out to say, hey, we're going to take it anyway and call this religious discrimination, when the call it the professional discussion among constitutional scholars and church state scholars was, whatever one may think of the merits of restrictions on funding to religious institutions, this case should be over, should just be a done deal, but not to the court, which reached out to do it. The other thing I want to point out, Dan pointed to one of the big areas that is left open by the decision. I want to point to another one. The decision doesn't address whether states are required to fund schools that discriminate in admissions or employment based on things like race, religion, sex, sexual orientation, gender identity, disability. many religious schools, maybe most, do discriminate in their admissions on one basis or another. It's not uncommon, just as an example, to exclude LGBTQ students or students with disabilities, or to require the student to be a member of the church and live according to the church's religious teachings. The court really bracketed the question whether the state can say where public money goes should be open to everyone as a potential student. So that's a question yet to be resolved.
Yeah, I remember doing a voucher panel when I was interning at Americans United last summer, so it's a very familiar issue for me.
You're kind of an expert on it.
I would like to move on to the topic of contraceptives, though, because I know that's a very involved topic. And the Affordable Care Act's contraceptive mandate in particular. Richard, before we get into the court's most recent decision on First Amendment and the contraceptive mandate, could you give a quick overview of just what the legal arguments are for and against requiring access to contraceptives?
Sure. So you have to start with the statute. The Affordable Care Act says that certain preventive care services are to be covered without cost sharing. And then there was written into the statute a process for, call it, expert determinations about what preventive services are and what should be covered. And the agency of medical experts that was set by Congress to decide these things determined that among the many things that should be provided for care, and under something called the Women's Health Amendment to the Affordable Care Act, should be all FDA approved methods of contraception that should be available without co-pays and things like that. So this was a statutory and regulatory requirement. To understand how the pieces fit together, there's this sort of puzzle that we have almost a decade of legislation and regulation, 8 years of litigation, 9 now, I guess it is, in scores of cases all across the country, 4 Supreme Court decisions. But it kind of comes down to, when it gets to be sort of what are the arguments, it comes down to this. Under the Affordable Care Act, most employers are required to offer their employees health insurance that includes coverage for contraceptives without deductibles or copays. And that's true for universities, for students as well, for those of you who are on a student plan. And thanks to this benefit, about 62 million people have gained access to birth control at no additional cost. From the beginning, houses of worship were exempted from the requirement, and the Obama administration also exempted other religiously affiliated nonprofits with religious objections, but it did it in a particular way. It said, if you object, fill out this form, give it either to us, the government, or to the insurance company that you have a contract with, and let us know that you object to the coverage. And then the government will provide the contraceptive coverage to employees, students, whomever, without co-pays and without involvement or pay or anything like that from the objecting employer or university. Supreme Court in the Hobby Lobby case held that under the Federal Religious Freedom Restoration Act, RFRA, you'll hear us call it, closely held for-profit companies get that same exemption. But the court gave an important caveat, and this is kind of where I want to sort of set things up. The court said that when considering religious accommodations, the First Amendment's Establishment Clause requires courts to take into account harms to third parties. If the idea is that if a government gives a religious exemption from the law to me in a way that imposes the costs or other harms on you, it's making you subsidize my religion, which is preferring my religious beliefs to yours and to your other rights, and that's unconstitutional. Now, the latest cases, and I'll just set this up and then we can kind of go from there. A bunch of religious nonprofits sued, arguing that signing this form, and a lot of you, most of you will know this, signing a form forces them to be complicit in the sin of contraception because, goes the argument, it triggers the government's provision of the coverage. When you sign that form as an employer, that's how the government knows you're not doing it. And so the government steps in and pays for the coverage. And so the idea is, well, if I didn't sign it, it wouldn't happen. Those challenges to those requirements reached the Supreme Court in 2016, but the Supreme Court really didn't resolve things, and the accommodation stayed in place until the Trump administration came in and kind of changed everything. It issued new regulations that give all businesses, nonprofits, for-profits, privately held, publicly held, you name it, the right not just to refuse to provide contraceptive coverage, but also to avoid filling out that form, so the government won't know that it's not being provided and won't do anything about it. A few different lawsuits were filed. We brought one of those. The one that got to the Supreme Court last term is called Little Sisters of the Poor against Pennsylvania, which is a suit by the states, Pennsylvania and New Jersey. Little Sisters in the name refers to an order of nuns that run a chain of nursing homes and intervened in the case. They're actually exempt. I've always found this interesting. They're actually exempt from all of these requirements under an entirely different provision of the Affordable Care Act, and never were subject to these requirements or had, in any sense you would normally think of, a stake in the outcome of the case. But they do make for great, shots on the news of the Little Sisters saying we're being forced to provide contraception, and that's become the kind of mechanism for talking about this fight, but again, not one that's actually correct. Anyway, in July, the Supreme Court upheld, at least for now, the Trump rules, though the litigation continues, and it did it in a really narrow way. In an opinion by Justice Thomas, the court held that Congress, through the Affordable Care Act, authorized federal agencies to issue regulations about required insurance coverage and to grant exemptions from those requirements. But that's it. It didn't say whether this particular exemption is unconstitutional. Justice Alito, joined by Justice Gorsuch, would have gone further, saying under the Religious Freedom Restoration Act, which I mentioned, the exemptions that are being sought should be required, never mind any harm to third parties, because, say these justices, nobody is actually being harmed by being denied the insurance coverage. People just aren't getting a goodie from the government that they weren't entitled to in the first place. I think let me stop there and see where it makes sense to go from here.
Yeah, I think that last point is a crucial one. It's this notion, no one's being harmed, you're just not getting a goodie from the government. That's all well and good in this context, but in other contexts, and I think we're going to talk about a few cases that bring this point up later. In other contexts, it's an absolute egregious violation of the Constitution not to provide government goodies to certain people, and that was also true in Espinoza. Frankly, it was basically, we're entitled to this government handout.
And by the way, Justice Ginsburg, joined by Justice Sotomayor, filed a dissenting opinion going through and explaining, and she did the same thing in the Hobby Lobby case as well, explaining in great detail lots and lots of ways that that real people, employees, students, are harmed if the government lets their employers or their universities effectively block their receipt of this insurance coverage. But the majority's view, and particularly Justice Alito's view, voiced again and again, is no, that's not a real harm.
I think we could probably have a whole panel just on the Supreme Court's birth control cases since the ACA was passed. If anybody has questions on this, please submit the questions through the Q&A feature, and we can get to them at the end. But I would like to move on to talking about Masterpiece Cakeshop, actually. So Dan, one of the most well-known religion cases to make it to the Supreme Court recently was Masterpiece Cakeshop, where a baker in Colorado refused to make a custom wedding cake for a gay couple because the baker claimed it violated his religious beliefs. but the court's ruling in Masterpiece Cakeshop was pretty narrow. So in your opinion, and then in Richard's definitely, what does the Masterpiece Cakeshop holding stand for?
I agree with your assessment. It was pretty narrow. The baker and its supporters were hoping for a home run. They were hoping to get the Supreme Court to grant a blanket First Amendment right to discriminate, and to discriminate in the provision of public services. They did not get that. They did not come close to getting that. And so I think there was some disappointment on that side. The court found that on the particular facts of the case, that there was religious animus directed at the bakery. It was a Christian-owned bakery, and it was based on some flimsy evidence, and this is obviously a fairly biased view of things since this was our case, but the evidence was, according to the court, that there were hostile statements made by commissioners who were members of the Colorado Civil Rights Commission in assessing the question of whether the state law had been violated. This is a public accommodations law, and the question is, was the law violated? I think there's little doubt that the law was violated, and yet in coming to that conclusion, one of the many steps along the way in the state process for assessing whether the state law was violated included statements that the court interpreted to be hostile toward religion. And they also saw evidence of religious hostility in the state commission's refusal to pursue complaints against 3 other bakeries that had refused to make cakes with anti-gay messages. And adding all of those things together, the Supreme Court concluded that there wasn't the appropriate level of religious neutrality in the case. It declined to establish a much broader rule that would have really driven a hole through civil rights laws. And in fact, to the contrary, the court included a fair amount of language reminding us all that there is a general rule that religious and philosophical objections don't allow business owners to deny protected people equal access to goods and services. So it was a battle. It was far from the war.
The thing, Dan gave you a feel for the facts a little bit, and because that's how the court decided it. There are 2 things I wanted to say about that. One is, and it gets into the category of one of the things that makes me crazy about that decision, is that the thing that, so that was when Justice Kennedy was on the court, and the thing that seemed to so it was a different court, but this thing that the court seemed to point to as the great example of evidence of religious hostility was a comment by one of the commissioners. So it's a panel of people who decide whether there's been a violation of the law in the first instance in an administrative process. One of the commissioners said something, and I unfortunately don't have the exact language in front of me, but something like, throughout history, there have been some really terrible things done in the nature of, in the name of religion. Now, when I was sitting in the court, as Dan was, when the case was argued, and when I heard the justices really fixate on that line, I took from the briefing and from the record what the precise statement was, and for several months I just had it in my pocket, right? Because I deal with a lot of work with a lot of clergy in our work every day. And so when I would be visiting with them about whatever, I would pull it out and say, what do you think about this statement? And 2 of 1, they all said, well, that's true. What about it? It is true that some terrible things have been done in the name of religion, also some wonderful things. You have to understand in a reading of history that both of those things are true, and that what the commissioner was saying was something that most really serious people of faith and religious and spiritual leaders recognize to be true, though only part of the story. That's what the court thought was this grave example of religious discrimination. And so because of this funny thing that went on, one of the things that's happening now is there are lots of these cases still floating around in the lower courts, is that the folks who are pushing them are going back and trying to come up with anything that they can to say, here's an example of a religious discrimination in applying the law to us. And one of the arguments that's becoming popular now, but we haven't seen exactly how the courts will treat it, is the mere fact that you decided to enforce the law against me when I am a religious person or religious business means that you are discriminating against religion, and therefore it should be unconstitutional. That's a pretty odd way of thinking about discrimination. Applying a law equally itself can be a problem, but those are the arguments that we're seeing, and the courts have to figure out what to do with those.
Yeah, and one more thing about the statements and the Supreme Court's assessment of what constitutes religious animus. That decision in Masterpiece Cakeshop came down within weeks of another decision by the Supreme Court in which it upheld President Trump's Muslim ban. There were arguments in that case too about religious animus. And the evidence, you heard Richard explain the evidence in Masterpiece. The evidence in the Hawaii case, which was about the Muslim ban, was unmistakable in its hostility towards Muslims and Islam. President Trump he said, I am calling for a ban on Muslims entering the US. And he said so many other things like Islam hates us and we're having problems with Muslims coming into this country. And then he enacted a ban, which, although it didn't mention Muslims by name, singled out Muslim majority countries, and nearly all of, about 97% of the hundreds of millions of people affected by his initial ban were Muslim. And yet the Supreme Court was willing to just overlook that entirely, and they gave him a free pass. And that wasn't the only evidence. There was a lot more. I mean, he endorsed a false story involving General Pershing and the supposed massacre of Muslims dipped in pig's blood, and he retweeted all sorts of flagrantly anti-Muslim videos, and the court just let it go. And yet in Masterpiece, on much flimsier evidence, and the court said no, that was impermissible, unconstitutional religious hostility. So contrasting the two cases, it's really stark.
That's a really great comparison, Dan. Thank you. I haven't heard those two cases just compared that way before. But they happened in the same term, weeks apart. It was crazy. That's insanely frustrating. But because we have more topics, this is just such a really robust area of the law. So Richard, I did want to ask about another case that was decided this past summer, Our Lady of Guadalupe versus Morrissey-Berru, which greatly expanded what is referred to as the Ministerial Exception. Can you explain what that is?
Sure. And I want to start with the facts because I think that they're helpful. 2 fifth-grade teachers at private Catholic schools brought employment discrimination suits. One was under the Age Discrimination in Employment Act because the teacher was fired when she turned 64. And the other was under the Americans with Disabilities Act because the teacher was fired when she was diagnosed with breast cancer. Now, the schools in both cases defended by invoking this ministerial exception, which is a judicially created doctrine that exempts religious institutions from things like employment anti-discrimination laws with respect to their clergy. And I'm going to put a little star by that to say what that means in a moment. Now, the idea behind the doctrine is this. This is how the courts have described it in developing it. Houses of worship have to be free to decide what their theology is and how they're going to, propound it, right? Your clergy are how you develop and teach your religious doctrine. So you have to be entirely free to pick and choose your clergy in order to be free to decide on your religious doctrine. It's instrumental. The freedom with respect to choosing clergy is instrumental to the freedom to pursue your religious mission. That's the idea. What's odd about the ministerial exception is that it doesn't just exempt houses of worship and religious schools from employment discrimination laws when they make religious judgments about who to hire and fire. It applies to all those employment decisions. What do I mean by that? Well, look, the federal employment discrimination laws already exempt religious employers from the bar on religious discrimination. You aren't a member of your denomination, we don't have to hire you. You aren't living according to our religious rules, you're fired. All of that is legal. And that goes for all their employees, their pastor, sure, but also the janitor and the file clerk and everybody else. The ministerial exception comes into play when a religious institution either refuses to hire you or fires you for non-religious reasons. That's the only time it really matters. The church says, we don't want a black pastor. We don't have a religious reason for that. Some of us just don't feel comfortable around black people. The sort of argument that couldn't possibly fly for any other employer, and we haven't thought that for half a century. The Supreme Court said in 2012 that if those sorts of laws were applied to churches hiring and firing of those who preach, teach, lead the congregations, it would end up being the government interfering with the church's religious mission. So you can't do that. Enter those two teachers I told you about, Kristen Beal and Agnes Morrissey-Berru, fifth grade teachers, each of them at different Catholic schools in California. Again, one was fired when she got breast cancer, the other when she turned 64, because look, the school's insurance rates might go up if there's expensive medical treatments being covered by one of the employees, and older, more experienced teachers get higher salaries than teachers right out of college. It used to be really common for people to be fired for those reasons before the federal laws kicked into place. Now, the majority of the Supreme Court this past summer concluded that both of those teachers legally counted as ministers for purposes of the ministerial exception. Remember, they're fifth grade teachers, even though one of them did very little in her religious job and the other practically nothing. Neither school required it. They were Catholic schools, but neither school required its teachers to be Catholic. They weren't what you would call spiritual leaders. They were just ordinary classroom teachers. What the court did was it didn't give us a really clear test for deciding who's a minister and who isn't and who the law applies to. But it said this. It said that you have to look at what people do, look at their job functions day to day, and the court has to decide. Justices Thomas and Gorsuch would have deferred entirely to the religious school and said, hey, you tell us who's a minister and whatever you say goes, but a majority of the court said, no, it's a legal test about a legal right. So we the courts get to decide. All that said, what I think the court did was to encourage religious employers to be really bold in asserting this ministerial exception to try to strip all the protections against workplace discrimination from as many of their employees as possible. Teachers, sure, also other employers at other religious entities, nurses at religious hospitals, just to take one example. Justice Sotomayor said in a dissenting opinion, when you're talking about teachers like math teachers and computer teachers or teachers who just read stuff out of a workbook, they aren't doing what you think of as a minister supposedly doing. They aren't doing this religious function for which discretion really matters. Religious discretion, religious determinations matter. So why are we extending this protection for choosing your clergy for religious purposes to things that it just doesn't apply to? But now we're sorting out in the lower courts exactly how it does apply, given the placeholders that the Supreme Court has sort of given us.
Yeah, so just two quick additions to that summary. And this one is just a follow-up on what you already said, Richard, which is that not only is there an incentive for religious institutions to try to go out of their way to classify everyone as a minister, but in fact, they're getting advice from a whole slew of attorneys who are trying to push ways in which you can do that. Here are the steps you can take to make sure that everyone from top down counts as a minister. And why? It's so that they don't have the benefit of the civil rights laws. I mean, it's one thing to say that the leader of your congregation should be chosen based on criteria that the courts have no say in. Fine. It's quite another to say that someone who has really no leadership responsibility when it comes to spreading doctrine should also be completely barred from bringing discrimination claims. And again, just following up on something Richard said, we're now, once the definition of who is a minister is so expansive, then we look at, well, what does that mean? What claims are they not allowed to bring? One thing we know they're not allowed to bring are straight up employment discrimination claims. Right now, there are disputes working their way through the lower courts about what other claims. And one area that has come up in a few cases is hostile work environment claims, sexual harassment claims, or other kind of harassment claims. Are those two barred? Once you're a minister, you can't bring any claim against your employer for active harassment and hostile environment claims. And who knows what kind of reception they're going to get in Supreme Court, but I think we have some signs already.
Yeah, and it's worth taking just a second to pause and think about to think about that, because if you under the ministerial exception, if you have a rule that only men can be clergy, you get to do that, right? And the laws against sex discrimination don't apply. But you don't assert that. You ordain women as well as men, and you hire women to be teachers as well as men to be teachers. But that there's the supervisor is sexually harassing or assaulting the employee. That the assertion is, well, that gets protected in the same way. To me, that's miles away from the religious interest that this is all supposed to be about. And it has what I think can be some really pernicious consequences, and we have to see what the courts will do. But it's very, very worrisome.
I remember reading that decision last summer. It's extremely concerning. I did appreciate the dissent, but it was sad.
I feel like I say that a lot these days.
Okay, the last case I wanted to talk about, we don't have a decision in yet. So Dan, last November, the Supreme Court heard oral argument in Fulton v. City of Philadelphia, where actually Georgetown professor Neil Katyal argued on behalf of the city. Could you tell us what's at stake in Fulton and when we should expect a decision?
Yes, this is a case in which a religious foster care agency, Catholic Social Services, says it has a right to discriminate against prospective foster families using taxpayer dollars when it's performing this core government service. And the government service is assessing whether families who want to foster are qualified. So in other words, they're arguing that they have a free exercise right and a free speech right to get a government contract to perform a core government service, which is, again, certifying foster parents as being qualified, and then to change the terms of the contract with the city to be able to discriminate. Everyone else who has a contract with the city cannot discriminate, and with good reason. But this agency is asserting a right to do it. There were two agencies that the city found out had been discriminating in these qualification decisions, in these certification decisions. And the city went to them both and said, you know, we have a rule against this. We didn't realize you were doing this. And one of the agencies said, okay, we'll stop doing it. But the plaintiff in this case said, no, we want to keep doing it. We want to keep discriminating, and we want to get a new contract, and we want to change the terms of that contract. So this could allow, the implications, this could allow taxpayer-funded agencies across the country to turn away qualified families simply because they don't meet their religious test, because maybe they're LGBTQ or of a different faith, and I'll let Richard talk in a moment about that, or if they don't go to the right church or anything like that. And this case does raise some of the same Masterpiece Cakeshop type arguments about hostility toward religion. Again, there were certain comments that the plaintiff seized on to say, wait a minute, this shows that you're against us because of our faith. But here's the thing, the city still has a contract with Catholic Social Services for other foster care services, just not this one thing. And in all those other instances, they are willing to comply with the contract requirements. So as a result, the city is still paying them $17 million for those services, which was almost the entire amount that they paid before. So only a couple million less. So the vast majority of money is still going. This is taxpayer dollars still going to this agency. And yet they're claiming that they are being discriminated against because they are not allowed to discriminate and change the terms of the contract to perform this key important government service. Richard has a related case going on, not in the Supreme Court. So we represent interveners in the Fulton case, but I'll leave it to Richard to explain his case because it highlights the real problems in this area.
Yeah, and in fact, if I can do it quickly enough not to burn all our time, I will tell you about two. The one Dan was referring to, we have a case in South Carolina where we represent a mom, a family, where the family wanted to mentor and foster kids in foster care. Foster kids are in the custody of the state, meaning that the state has responsibility for them and is supposed to place them. But South Carolina, like most states, maybe all of them now, have contracts with private entities to go through and place the kids. In the part of the state that my client, her name is Amy Madonna, where Amy lives with her family, the only game in town happens to be an evangelical Protestant organization. Amy went and was told by the Department of Social Services, the state agency, this is where you go if you want to foster kids. She went, she and her family go through the whole process. And the people from this agency that's funded by the state and the federal government to place foster kids say, oh, you're just perfect. You're exactly what we want. Just the kind of family we're looking for. Just need to know one more thing. I guess it's two more things. Tell us what church you go to and who your pastor is. And Amy says, well, I don't have a pastor, I have a priest. And she gives the name of the Catholic church she goes to. And the person from this agency says, oh, well, we don't do Catholics. We won't work with you. Never mind that it's a state program and federal money going to it, and the place where in the Greenville, South Carolina area, that's where you go if you're going to foster. But she wasn't good enough because she was Catholic instead of evangelical Protestant. And so that meant, no, you're just not good enough. We've sued on her behalf. We also have a suit on behalf of a couple in Dallas where they wanted to foster a child through a federal program that is, well, it's the federal programs for housing refugee children. And what happened was is one of our clients had gone. She runs an immigration clinic at Texas A&M Law School, and so she was working with this local organization that has the contract with the federal government to place refugee kids, and she's helping them with the law and doing presentations there and everything else because they've asked her to. And she decides this is really a great and important program, so she goes home and she says, "Hey, we should foster." And her spouse decides what a great idea. They go and they apply, and then the organization says, "Oh, well, you happen to be two women, a same-sex couple. Sorry, we won't take you because your family doesn't mirror the Holy Family. And so you can't participate in the federal program, or really, like with my client Amy Madonna as well, you aren't good enough to provide a loving home to kids because we don't approve of you for our religious reasons." And we see these things over and over again across the country. What the Fulton case is going to do is at least set down some markers. We don't know how much it will or won't decide, but resolve at least some of the questions about whether they get to have contracts to use government money to perform a government service, and to do it saying, "We won't work with you if for religious reasons we don't like you."
In answer, I forgot to answer your question about the timing. So first of all, one interesting thing about the timing is that this case has been argued, not yet decided. It was argued the day after the election. So normally, I think many more people would be focusing on this and paying more attention, but we had other things going on in the country at the time. As for when we can expect a decision, who knows? I mean, we know it is almost certain that we will get a decision by June, by sometime in June. I guess the court could go later than that, but that seems highly unlikely. Beyond that, not really sure. This is one of those cases. The court tends to hold its decisions in some of the more high-profile cases till the end. But this was argued in November, so by that point it'll be pretty late. So sometime between now and June is the answer to that.
Okay, I will be anxiously waiting for that all semester long. So I see that we have about half an hour left. So I've got some general questions for both of you to wrap up my questioning, and then I would love to open it up to any of our attendees' questions. So if you're watching this, feel free to start using the Q&A feature and sending questions in while I ask Richard and Dan my last few questions. So one of the themes we've talked about is that the Supreme Court has really taken a sharp turn in recent years. So knowing that the Supreme Court is less friendly to your arguments than maybe it used to be, how have your litigation strategies changed?
Do you want to start, Dan?
Sure. We're being careful. I think it's safe to say. We certainly have not stopped litigating. There's a great deal of work to be done, even with a court that may not be receptive to our claims. Number one, not all cases go up to the Supreme Court, and only a tiny percentage of them do. This is a court that does seem to be quite interested in religion law. So I think the usual percentages might not quite apply, but it's still the case that if you bring any given case, it is unlikely to make its way up to the Supreme Court. Also, I'd like to think that even if the court is not inclined in our direction, that there's still room for convincing, depending on the issue. So we do have to be careful about how we pick and choose our cases, but that's always been the case.
Yeah, I think that's right. We have always tried to be incredibly careful and strategic and thoughtful. And this is where, look, when you spend all your time thinking about legal arguments, and then you have to sort of step back and say, facts matter, because they determine how people think about things. And this is, I think, really good to remember when you sit down to write a brief or whatever else, is that the frame that you put on things and the details are going to matter. And that there continue, I think, to be situations when even with courts that may not be very hospitable to the claims will go just too far. I did an oral argument in a case last week where that was so, and or certainly seemed to be so. And it wasn't the case that there was a political split or a left-right split or anything like that among the judges. They thought that there was something essential to be protected in religious freedom, for which the First Amendment's Establishment Clause does that, and were willing to and seem to be prepared to decide that way. We'll have to wait to see, but that's what you think about and look for.
And one important addition here, this probably goes without saying, but our organizations do a lot more than litigation, and so it is important to keep up the pressure on all the other fronts. I mean, that's everything from grassroots organizing to lobbying and the like. One example of this, we talked about the Muslim ban case, which, again, I continue to think was a disastrous opinion. On the other hand, on day one, it was repealed. The Muslim ban was repealed by President Biden. So there is a fair amount of wiggle room in a lot of what we do that's outside of the courts.
Yeah. Litigation, but also all those other forms of advocacy can really shine a light on problems, and that matters. It remains to be seen across the range of things what the new administration will pick up, but it certainly is a time when we can think about and hope for some help in that regard, in at least not doing more bad things.
Yeah. So I have one last question for you, and then I see that we've got some questions rolling in. I'm excited to get to those. But what would you say to a law student looking to enter your line of work?
I would say, please do. Don't, go in with your eyes open. Go in knowing that the challenges lie ahead, particularly given everything that we just discussed. But we need more people doing this work, and as we just said, it's work in the courts, it's work in legislatures, it's organizing. There are many ways to promote these sorts of constitutional values that we hold so dear here. And I think it's great. And frankly, the number of organizations that are doing this kind of work, what I'll loosely call on our side, has grown just as it has on the other side. And so the opportunities, while not legion, are there are plenty of them out there. So I would encourage you, if this is your passion, to pursue it.
That's right. It's a fascinating and important field, even in challenging times. And so I'm going to throw in a little commercial here, which is, so Kalli spent last summer with us as an intern, which we do. We also have 2-year constitutional litigation fellows for people either who, if you've just finished clerking or you've just come out of law school or you're a couple of years out, and it's a real opportunity, I think, to do the work. And then, as Dan said, there are more folks doing it than there used to be, and that's a good development. We work very closely with probably everybody who does, and really all try to think carefully and strategically and see what we can accomplish. And the same thing with, for me, the folks down the hall who do the policy work, and the folks who down the hall who do the grassroots organizing. So there are lots of opportunities, local, national, you name it.
That is, great to hear. All right, let's get to these questions. The first one I'd like to ask is from Rajuda, who's actually president of our chapter of ACLU. She asks, do you worry that growing political polarization will mean that religious protections may yo-yo back and forth depending on which party's in power? If so, what consequences do you find the most worrying? If not, which protections do you predict will remain most stable?
Start, Richard. Go for it.
Sure. Yeah, look, there's always some back and forth, but there are also some bigger trends. And so I'm going to talk about 2 things to give you to give you how I think about it. One is the increasing recognition of LGBTQ rights, for which the Supreme Court's decision and the Bostock decision at the end of last term made clear that, you know, recognizing that the word sex discrimination in Title VII mean sexual orientation and gender identity also has really broad implications. And it also speaks to the way that the world has changed from 20 or even 10 years ago, that there are incredibly important rights that are now widely accepted. The flip side of that, that's also a trend, and that I think gets to the question, is now these fights are being fought as, are there going to be religious exemptions from those laws that can erode or erase the hard-won protections? And yeah, there's a lot to be worked out. I tend to think that while some things change from administration to administration, the longer term arc in the courts is probably the more important thing, and trying to figure out what that's going to be now with so many newly appointed Trump judges, and that being a watershed change, we'll have to see. But it looks like more and more now there are going to be a bunch of opportunities for this administration to make appointments. So we'll see.
Yeah, I do think that there is going to be an inevitable give and take in terms of these protections that we've been talking about. Things I'm worried most about, I would say, are attacks on, as Richard said, on LGBTQ rights, and in particular, trans rights. And I'm very worried about that. I think the religious attacks and gaping holes of exemptions for religious reasons are one of the problems. They are not the only there. That is something that I'm concerned about, even though I also agree with Richard that we're moving in the right direction. Absolutely. I'm very worried about the separation of church and state. I think that is something that is flying a bit under the radar in the national conversation, but in the courts, it's really being undermined. And that is very court dependent. And so unlike some of these other things, that's not necessarily fixable outside of the courts. That said, one thing that I think will continue to be fairly solid is the church-state protections in schools. I think that is where the case law is most robust. The courts have been very careful to ensure protections in that context, and that has to do with, you know, a lot of things. You have to go to school, kids are young, the impressionability of youth, all that. I don't worry as much in that area. I don't think we'll see as much pullback, but who knows? I mean, even there, we can see problems.
That's actually a good segue into this next question from Megan Lipsky, who is a fellow AU internship alum. She asks, what can law students do to ensure that the separation of church and state remains a priority for this and future administrations?
You want to start, Dan?
Well, I mean, hopefully things that are already ongoing, like making sure, you know, it's hard. Not everyone has a direct connection to folks in the administration. So I think speaking out publicly, you know, writing op-eds. Richard mentioned several times, importantly, the facts of these certain cases. Sometimes the separation of church and state can be viewed too abstractly, and there's great value, I think, in reminding people, no, this is something that affects people, individuals, on a daily basis. And when you start telling the stories, that really helps. And there are many ways that you can tell these stories. You can tell them through litigation, you can tell them through public education. But when you remind people, this is not just some notion up there in the clouds. This is this kid getting harassed in school in Louisiana for being a Buddhist and going home crying every day, or whatever it may be. When we humanize this very important constitutional principle, I think that helps a lot.
Yeah, I think that's right. And these stories are not only are they important, but they're all over the place. Some of you, many of you may have your own stories and experiences to contribute. That helps a great deal to be willing and able to voice those, as does just the awareness that, you know, for a long time we have felt that the big civil rights fights of the day across pick your favorite 10 issues are at their core church-state issues. But it's only much more recently that that's sort of been widely recognized, right? So spotting where it comes in matters. Another thing that I think I would add is we do an enormous amount of work with lots of religious organizations, denominational organizations, and others, because there is an attempt from the folks on the other side of these issues to paint trying to protect the separation of religion and government as hostile to religion, and having strong religious voices saying, no, this is how we protect religious freedom, the way that people in this country, including the founding generation, have thought of it all along. That's immensely important. It takes away the us versus them, and it takes away the you must hate religion and be hostile to it, and instead is, let's really think carefully about the protections and whether they apply to everyone. Everyone, regardless of whether you're of the minority faith, the majority faith, non-believers, and so help in that also matters.
Absolutely. And talking about forming—
And by the way, hi, Megan.
Forming those alliances and relationships is really important. And that's a good segue into a question from Rachel Schwartz. She asks, freedom of religion organizations from across the political spectrum have been allies before, for example, in passing RFRA. What are some places, if any, that might be common ground now for those organizations? And will this influence your litigation strategies?
Yeah, I'll start. First of all, hello, Rachel. Good to hear from you, Rachel, a member of the ACLU family. Yeah, there was a broad coalition that supported RFRA at the time, as the question suggests, from across the spectrum. I think their areas of common ground these days are a bit harder to find, frankly. There has been more polarization within the religious liberty law community that probably mirrors that's going on in the country as a whole. I think there still are some areas where there's common ground. One example, opposition to the death penalty. There is religious opposition to the death penalty that I think comes from many different spots on the spectrum. Not everyone, certainly, but other things like that. The sanctuary movement to advocate for immigrants' rights, for example. There are areas like those where there can be common ground, and I think that's true in litigation, but it's also true in non-litigation type advocacy. It's a little harder to come by, to be honest, than it was in the past.
That's true, but let me give another example, although it requires me to get a little bit technical, but I'll try not to sort of lose myself in this. There has long been really broad consensus across the political spectrum, the religious spectrum, and everything else, that if religious or faith-based organizations are providing social services under contract with the government, getting paid by the government to do it, that these services should be available to everybody. And that means some particular things, like if you go to a social service provider for a government program and you don't feel comfortable there because of its religious bent, that they give you a referral to another one. And that in the same way, if you have objections, or or if you're treated unfairly, I guess I should say, that you're informed of your rights. There was, going back to particularly the George W. Bush administration, folks got together across the political and religious spectrum in coming up with rules that became the federal regulations, saying that those requirements, if you're going to be a contractor to provide a government program and you're religious, you have to adhere to them. You have to give referrals to people, and you have to tell them of their rights. Out of nowhere that we can tell, the Trump administration, right at the end, passed a new set of regulations, kind of throwing out all those regulations in the federal agencies and saying organizations no longer have to do that. And there no longer has to be a secular alternative provider for those who want that. As I say, those were things that people across the board agreed on, and I think still agree on. It's a funny thing that the administration decided that it could, I don't know what, curry favor with certain folks by pushing an agenda that nobody particularly wanted or needed, and that folks across the religious spectrum thought was unfair. But that's the world in which we live. We filed a suit along with several coalition partners a couple of weeks ago, challenging those regulations. But again, it speaks to the fact that there really is some broad consensus, even if, as Dan says, I think it's unfortunately less true than it used to be. There is some, and it doesn't mean that government doesn't run roughshod over it sometimes, but that's peculiar.
Yeah. So it looks like we've got about 10 minutes left and one more question. So that works out pretty well. And I think it's a good, really interesting question to end on. Megan asks, do you anticipate any upcoming challenges to the public display of religious paraphernalia after the Bladensburg cross case? So that's probably going to take a little explanation of what that case exactly stood for.
Richard.
Okay. So the Bladensburg cross case, there's in Bladensburg, Maryland, which if you just drive like 15 minutes, 20 minutes from the law school, you get there. Maybe it's a little more than that, but not much. There's this giant cross that's been there since, I guess it was the 1920s. That is on public land, and it was challenged a few years ago under the traditional legal doctrines about how government isn't supposed to be favoring any one faith over others, isn't supposed to be pressing or endorsing any faith over others. It's supposed to be neutral with respect to religion, so that we can all believe or not believe as according to the dictates of our conscience. The Supreme Court upheld this big cross display, and in doing so, it substituted a kind of legal analysis that we hadn't seen before, saying, well, when we look at these displays, let's look at history. And it was something like, well, what the founders wouldn't have had a problem with must not be what the Establishment Clause, the First Amendment's religion clauses were designed to protect against. So gee whiz, it must be okay. Never mind that the actual history is that there weren't these sorts of displays on public land. Government didn't do that stuff back at the founding. But that's a change to religious doctrine, legal doctrine, that we're now trying to work out. And in fact, the Seventh Circuit just decided a case the other day where it held that a nativity scene was constitutionally permissible in ways that we didn't used to think so. Not that they couldn't possibly be constitutionally permissible, but that you looked at all the facts and circumstances and you applied the legal test that had been settled for a few decades at least, and you would have thought this was not okay. The court decided the case and said that the display was just fine because it is part of our history of recognizing the origins of the Christmas holiday, which is kind of a weird sort of analysis. What does that mean for future religious display cases? I guess I don't know. Again, Dan pointed to schools. I would think that that religious displays in public schools should if there were any public school officials watching, I would tell them, look, don't make the mistake of thinking that the world is different for you. But for the rest of things, there's kind of a lot to work out. The Trump administration put in some regulatory guidance telling the federal agencies, spend more money on religious holiday decorations, knock yourselves out. When there's settled case law saying that what they would be doing is unconstitutional. But we have to see what the courts are going to do with that if the cases are brought, and figuring out whether one should gets back to what Dan was saying earlier about trying to be really strategic and figuring out where the courts are and what there is to protect.
Yeah, I'll just end on this. I think we're going to see less litigation in that area, but I don't think it will disappear. And I think a lot depends on how provocative any displays are. You get a sense on the court that even some of the justices that are perfectly fine with a 100-year-old cross might not be perfectly fine with one that you put up this week, and one that you put up this week and try to shove down people's throats with all sorts of expressly religiously antagonistic and hostile statements as you're doing. That you might get a different result there. So I think we'll have to wait and see. You also see, as Richard mentioned, the tests that are being used. You see the court struggling with how to approach this. There has been some animosity, some hostility by more conservative members of the court over the years toward the established tests like the Lemon test or the endorsement test. But I think even in those circles, there's a real struggle over what should replace it. And what should replace it has to be something more than seems okay, which is sort of what they've done so far.
And that gets to for the person who asked about what if you want to go into this field. One of the things that I have found so interesting, challenging, fun, exciting, frustrating, you name it, is the fact that even in a context where maybe for a long time we haven't had a majority of the justices happy with call it the settled tests, they can't figure out what to substitute and agree on it. And that means that there is in an area of the law that you can learn and become an expert in comparatively quickly, that there's a lot yet to be worked out, and it will very much be in play in the coming years.
Well, I think that is a great note to end on. So thank you so much, Richard and Dan. Thank you to all of the people who attended this panel. I also want to thank our captioner and our AV support who were invaluable tonight. And I hope you all have a very good night. Thank you so much for coming.
Thanks.
Thank you. It's so nice to have been here.